Well, the Court of Appeal in the week affirmed the verdict of the Kano State Governorship Election Petition Tribunal when it sacked Abba Yusuf, candidate of the new Nigeria People's Party, that is the NNPP, as governor of the state. The court, in judgment delivered on Friday, a three-member panel held that NNPP breached the constitution by sponsoring Yusuf, who was not a member of the party when the election was held. The court held that Yusuf's name was not in any of the membership registers of the NNPP tendered before the tribunal, a contravention of Section 177C of the 1999 Constitution. In Zamfara State, the Court of Appeal also sacked Governor Dauda Lawal of the People's Democratic Party (PDP) and ordered the Independent National Electoral Commission (INEC) to conduct fresh elections in Maradu local government, in 4 wards in Brining Magaji local government, and some polling units in Bukuyum local government. While the government of Zamfara State says it is not bothered about the verdict because the court did not say that the governor did not win the election and that it has the option of appealing the judgment at the Supreme Court, the main opposition, All Progressives Congress, APC, is excited about the ruling, hoping to finally unseat the governor in the rerun election. Meanwhile, the Court of Appeal sitting in Abuja reserved its judgment in the electoral dispute in Nasarawa State after the election tribunal declared the candidate of the People's Democratic Party, David Ombugadu, the winner of the state governorship election, sacking Governor Abdullahi Sule of the APC. Now, what does the verdicts from the Court of Appeal portend for future elections in Nigeria and the entire electoral process? All right, to help us understand the issues thrown out by these judgments, we have joining us in the studio joining us in the studio, legal practitioner and public affairs analyst, Rilwan Okpanachi, and also joining us in the studio, another public affairs analyst, Dr. Law Mefor. I also have with me here in the studio the special advisor to the sacked governor of Kano State on national and international public relations, Mohammed Yusuf. Gentlemen, that is Law and Jamiu, you're welcome. So we start with you two gentlemen. Like you heard me ask there, I'll start with you, Law, even though Jamiu is right by my left, but maybe because your name is Law, even though you're not a lawyer, as you told me. Just like you heard me say there, what does this portend, the entire gamut of what is playing out at the state and the appeal courts? Before we start breaking them down, what does this portend for our elections, for future elections, for the parties, and for the electorate?
First and foremost, I would say that it's a mixed grief for me. Not such a happy moment for those of us who are in a hurry to see democracy in full kicking in Nigeria. To begin with, I don't think it is a good thing for any democracy, Nigerian democracy, to harbor an election that will be determined by the courts. For me, an election must be based on votes. Who won? Based on votes. But we are seeing more and more of technicalities. Look at the case of Kano. We are talking about a candidate sponsored by a political party, but the court says you are not a member of the political party. For me,
according to the Constitution.
According to the Constitution. And if you look at it from that perspective, from the perspective that this is the position of the Constitution, and weighed against what it ought to be in a democracy, you will see that we are in a kind of quandary. I believe that the wishes of the Kano people have been upturned, overruled by that provision of the Constitution. For me, therefore, it's not a very happy thing that Kano people decided that this is who should be their governor. And the clause in the constitution is saying it's not.
Are you saying that it's good to go against the constitution?
No. That's why I'm saying
unlawful things.
No. That's why I said that is a mixed grill for me. And that is one area of reforms that must be addressed seriously. Because for me, membership of a party is an eternal affair. I believe the party should tell you who their members are. You get my point? And I am not aware that the contention is coming from NNPP itself. If it's not coming from NNPP, whoever is coming from outside another political party to begin to question the membership in terms of qualification of the governor, for me, is a meddlesome interloper. It is not right. The court has just overruled the Kano people by saying that the governor is not a member of NNPP.
I am sure.
That's what
your opinion, of course.
Yes.
I am sure that Jeremy is enjoying your submission. But then I come to you. Isn't it funny that in Bayelsa State, before Doye again, the courts brought him to the office?
Yeah.
What caused him to lose an election that he won with his candidate was the fact of the party did not realize, I don't know whether to use the word foolish, that he didn't have the right qualifications. It sounds childish to me.
It does.
Now, Jeremy, on that basis I come to you. The angle the court sacked your principle is that the name of your principal was not registered as a member of your party.
Yeah.
Now, don't you think that that is pedestrian, elementary? How can your party make that mistake?
Thank you so much, Indy. And Nigerians, my greetings to everybody from wherever you are watching us. What happened yesterday at the Court of Appeal is nothing but a miscarriage of justice. And I can be bold enough to tell you there was no constitutional breach. And why I have to tell you there is no constitutional breach? The judge, in his wisdom, a three-man panel took a decision that in the register of the NNPP that was submitted to INEC of 3 volumes, they have not seen the name of His Excellency Abba Kabir Yusuf there. But when we are talking about register of a political party, and when we are talking about decisions of the court, I have heard lawyers several times say the latest judgments are always the precedents and what should be followed. Very recently, in less than 3 months, a 5-man panel of the Court of Appeal, that is a full panel of the Court of Appeal, and you need the full panel of the Court of Appeal to be able to make a judicial constitutional pronouncements, not a 3-member panel. A 5-member panel that has wonderful judges like Justice like Justice Samani and Justice Mohammed, I can't remember the other names, made a pronouncement on a similar matter. What Justice Indumen made in his own pronouncement, he cited Section 177, subsection 6 of the Constitution of the Federal Republic of Nigeria, and went further to align with Section 77(2) of the Electoral Act. But this 5-member panel of the Court of Appeal, headed by Justice Samani that time, took the same route and made pronouncement and interpretation of Section 133. 177 is in relation to governorship election. 133 is in relation to presidential election. And it talks about the qualification that you have to, 1, belong to a political party, and then a political party sponsors you. And the same contention was of the voters register that a candidate's name did not belong there, of Peter Obi, not being on the register of that political, of the voters register of the political party. And these judges, in their own interpretation of Section 133 and equally interpretation of Section 77 of the Electoral Act, went ahead and went further to make such pronouncement that the issue of a political party membership is not the concern of any other political party. No party has right to look into the affairs of any other political party. The only thing another political party can do is to just be an onlooker. And they went further to say, even if the political parties have right to look into affairs of a political party, that the matter is statute bar because it is a pre-election matter. That was the judgment 5-member panel of the Court of Appeal delivered on the same matter that we had before Justice Indumen and the 3 other members of his panel. And that judgment of the 5-member panel cannot be set aside by a 3-member panel of the same Court of Appeal. Equally, the Supreme Court has made several pronouncements on issues of membership of political party. And let me go further to even tell you this. This time around, when we are going for the elections, what INEC did, they devised a new strategy. Every political party was given a code which they will upload the names of their candidates. And you cannot even upload the name and form of your candidate. You must include the voters, the register of the party registration card of that candidate. And I know in several instances, I can remember when I was in the People's Democratic Party, we have had a case of issue of who has the right to determine who is its member. We have gone on this matter from the court, High Court to the Court of Appeal up to the Supreme Court. And what the Supreme Court and Court of Appeal held is that the leadership of the party, that is the National Working Committee of the party, is the only organ that has right to determine who its member is, not the court. So it's like a son and his father. I cannot come to your house, Mr. Indy, and look at your son and say he's not your son. I do not have that right. You are the only person that has the right to say.
That analogy applies in this case.
Okay, if that analogy does not apply in this case, let me tell you an analogy that Justice Indumen used in coming to the pronouncement of his just decision. He cited allied matter in a political election matter. And he said, quote, it's like someone who is going to the Corporate Affairs Commission to register a company. He has to include the names of members who are shareholders in doing that registration. Yeah. But you cannot cite that matter in an election matter or a political party matter, because no political party has any. There is no decision or there is no embargo in any political party on modus of registration of its members. They can register before the primaries. They can even do new registrations before or after the submission of the voters registered to INEC.
That sounds funny to me. Let's bring
There is nowhere, let me just learn, there is nowhere in the law where it is stated as a mandatory that name of a candidate must belong in the register of the political party.
But we just quoted 177C, and that's the basis that the court sacked your president.
Did 177C mention register of a political party?
Well, it says what was found.
It just talked about
not a member.
What it says, what 77C says, the eligibility of an individual to become a member, he must be a member of a political party and be registered and be sponsored by a political party. How do you determine the membership of a political party?
Well, that his name...
You can register online.
That his name wasn't on the list. Let me bring in Rewan up, and I'm sure you're ready now. Good. Several issues are being raised here. And it borders on... I am in a quandary myself, and it borders on confusion, really, because you have a 3-member panel adjudicating, and Jamie pointed out a 5-member panel adjudicating on the same judgment. Now, that's one issue you're going to tackle as a lawyer. Where does this leave us? Because there's been so much talk about the fact that there seems not to be an agreement between judges in their judgments. That's one. And then secondly, Law talked about he's not very comfortable with courts determining elections after people have voted. But when parties or political players disobey the Constitution, what does that leave us? Rewan.
Thank you very much. The court is there to intervene when there is non-compliance with the electoral law and the Constitution by either the political party and its candidate or the INEC as the umpire. As regards the fact that there is a subsisting judgment of a court of appeal decided by 5 justices as against the recent one decided by 3 justices, I think both are judgment of the Court of Appeal, and it seems conflicting as it is, but the law is that where there are conflicting judgments of the Court of Appeal, the recent one will prevail. So as far as this issue is concerned, it is the recent judgment that will prevail. However, the issue is beyond the Court of Appeal, because even the Supreme Court in the past has made several positions regarding the capacity, the locus to challenge a qualification of a candidate on the ground that is not a member of a political party, and the effect of same. And the Supreme Court, in plethora of authorities, held that it is the membership of a political party or issue burden of member of a political party is an internal affair of a political party, and that the court has no jurisdiction over same. And when you look at the provisions of the Constitution as relied upon by the tribunal, it says you must be a member of a political party and be sponsored by that political party. It settles the issue is very clear. Was the candidate of NNPP sponsored by the political party NNPP? Yes, the answer is clear. If the governor is not a member of the NNPP, could they have sponsored a non-member as governorship candidate of the party? The answer is no. So there's that presumption that it's a member of that political party because it was sponsored by a political party. I'm here, you are there. They didn't come or they didn't forward your name to INEC. They didn't go to the street to forward anybody's name to INEC. So he's a member of the political party for them to have sponsored and submitted his name to INEC as the governorship candidate of the party. So the issue is settled. And when the issue gets to the Supreme Court, I think it will go in favor of the governor of Kano State. But if we look at it, I hope you can hear me.
Before you go on, so where does that constitutional injunction, where does that leave us? Where that lacuna that his name was not found as a member? I mean, I've understood what you said, but where does that leave us? There seems to be a lacuna or confusion. That's how I started. What does that leave us?
You know, there's no confusion and there's no lacuna as far as I'm concerned. If you are saying the name submitted, membership register submitted to INEC, his name is missing, and I can say, okay, there's no law that says if somebody cannot join a political party after the submission of the register of members to INEC. The law is very clear that you are a member of a political party and you are sponsored by that political party. if there is that presumption that he's a member of the political party because he was sponsored by that political party, this is very simple. It's not a complicated matter. If you are not a member, the presumption is there. If we are not, if for the party to sponsor him as a governorship candidate of Kano State in result of gubernatorial election in Kano State 2023, it means he's a member of a political party. A political party cannot sponsor a non-member as its candidate. That presumption is there. It is not up for argument. It is not up for argument. As far as I'm concerned, the only issue the party or the opposition party, had against him is the issue of non-stamping and signing and dating of the ballot papers. That is a crucial issue. I think if the Supreme Court is going to uphold that judgment, it's going to be on the ground that the ballot paper were not stamped, signed, or dated, not on the issue of a membership of a political party, which has been settled by the Supreme Court. That is not an issue that can be raised by a non-member of that party. It's not an issue that can be raised by another political party, and it is not even it's a party affairs. It's not a matter that the court has jurisdiction over. So it is a case, it's settled. The law says you must be a member of a political party and be sponsored by that political party. And for NNPP to sponsor him, it presupposes that he's a member of NNPP. I am not a member of NPP, and that is why my name is not there as a governorship of candidate of NNPP.
All right, I raised two issues with you. Law talked about elections determined by the courts. Is it the fault of the courts or the fault of the political players? And how do we get around it?
Thank you very much. The court is there to provide justice. The court is there to provide remedies when there are wrongs. The court is not there for the fun of it. When parties have issues, conflicts, they are there to approach the courts of law. So the court is not wrong for intervening in the circumstance, because that is what it's meant to do. One, if there is compliance with the Electoral Act and the Constitution in the conduct of the election, on the part of the parties and on the part of INEC, I don't think there will be any business for the courts as far as elections are concerned. But because they are non-compliance, as complained by one party, the court must intervene, because that is the very essence of the court. Now, when you look at it critically, most of the cases that have been determined by the court are nothing but a clear case of non-compliance on the part of INEC, except on rare occasions where elections are nullified on the basis of non-qualification of candidates. Other areas, such as non-stamping, non-dating, non-signing, stuffing of ballot papers, overvoting, all these issues are a product of the corruption that has become entrenched in INEC. And this government must stand up and do a surgical operation on INEC. The problem of INEC is now beyond Panadol. And you can see the outcry that characterized the election in states like Kogi State, like Bayelsa State, like Imo State. It shows that the Nigerians are losing faith in as far as INEC ability to conduct free and fair election is concerned. And we must do something very drastic. Right. Because as far as election is concerned, the rule of law has been thrown to the dustbin by INEC in the conduct of election. Let me give you an example. In Kogi State, in the recent election, there was, pre-filled issue of a ballot, issue of pre-filled by a result sheet. INEC, through its press release, admitted to it and said it was going to discipline its members that were complicit. Up to today, nothing was done. INEC went ahead to declare the declaration, to declare the winner in the election. It shows that INEC has admitted that it is a corrupt institution.
No.
That is a clear case.
I'm coming to law. No, you're not being fair to INEC there, I must say categorically, because INEC did immediately the issue was raised. INEC took it up, said it's going to investigate. It's not over yet, the investigation. And INEC did clearly say 16,000 votes cannot, in those areas where there was an allegation of a resource being written, cannot upturn, margin of, what they call margin of lead. Yeah. So, INEC was very clear.
No, that is not the case. We are not on ground. That is not the case.
Let
me address that issue.
Hold on. Let me come to the studio. I was there, so INEC did. What he said about INEC, should INEC be blamed for the politicians who go at lengths to circumvent the law? And in this case, INEC was very clear, margin of lead. So there was nothing that could be done. If you carry the whole votes in that particular, in those particular areas, and give even to the candidate that lost, nothing was going to happen. And that was very clear.
Yes, I understand the logic that since the margin of lead cannot be obtained by the infractions committed by INEC staff, yes, that is logical. But that is not what Barrister Banachi is saying. Barrister Banachi is saying that, look, INEC ought to, even if it is just one result that was altered by its staff, be proactive. You see, in public life, in politics, in democracy, perception is everything. What the people think, what the people say. People see INEC as a corrupt institution, and they are not doing enough to extricate themselves from that damaging public perception and image. That is what Obanachi is saying. And I tend to align with him, and I'll tell you so. They just concluded the general elections that happened between February and March this year. INEC has a large number of people, of their staff, permanent and ad hoc, that committed electoral fraud, manipulation of figures. Between March and now, it's about 6 months down the line, INEC has not done anything. INEC is given prosecutorial power. That means that INEC can prosecute offenders in an election.
I want to stay with the appeal courts.
Yes,
that issue he brought now, we're going to treat it. We're coming back to it.
All right. So now you want to know who is to blame. The word independent you find in INEC is not for play. It is there to give INEC the kind of stature and character that he needs to be able to discharge its statutory responsibilities. INEC is a commission, it's a regulatory agency in charge of everything about the election, even election security. On the day of election, the IG will have to listen to INEC chairman. This will show you how overarching the power of INEC is when it comes to election. Now, you don't see INEC really going the whole hog. Let me give you just one instance.
Before you give us the instance, let me come to Jamiu. You know, we have two issues here: that of his state,
yeah,
and then that of Zamfara.
Mm-hmm.
Yeah, the same court of appeal,
yeah,
the same court deciding. Now, Jamiu, I know it's not your party, but then we're discussing these issues. In the case of Zamfara, I'll get back to you and get back to you, Rewan, on this issue. In the case of Zamfara, certain areas, votes were cancelled, were not conducted, were not done normally. So the governor of Zamfara state has also been sacked, and APC is hoping that with the rerun in those areas, they will be able to unseat the governor, the current governor of Zamfara state, who has been sacked also by the appeal court. Again, how do you look at it?
Well, it's sad. That's the first word that I'm going to use. It is really sad. And why I have to use the word sad there is that when people come out in their large numbers, when we are talking about case of Zamfara, because the case of Zamfara, there is a lot of similarity with the case of Kano. People from the opposition party who had nothing at the state, no local government chairman, no councillors, no commissioners, no elected representatives either at the state assembly or the national assembly, just the candidate and the people's belief. And people believed in those candidates and came out en masse and voted for them and changed the narrative of the state from a state that was controlled by another political party to a state that is now controlled by a different political party. And when people decide with their own mandate, it is always sad when at the end of the day, because of some technicalities, the wishes of those people are being truncated on flimsy, frivolous excuses.
Are these really flimsy, frivolous excuses?
If you cite the case of Kano State, it is so flimsy.
Oh, well, I have moved from Kano State. I mean, of course, I expect you to say that because he's your principal, so that is not surprising.
It's not about the issue of my principal.
No, but what I'm saying is...
It's not about the... Look, let me tell you one thing. Let me tell you one thing.
I'm talking about Zamfara State
Okay,
now.
okay.
I mean, elections are going to be... Elections were not held there.
Yeah.
You know, that's the embrolling.
Okay, let's cite the issue of Zamfara. People voted. And then during the course of those elections, some certain abnormalities took place, which are not the cause
of
by those people. For those abnormalities, will you just throw away the wishes of people, thousands of people, just because of some little fractions?
When we say, let me get to Banachi, Rewan, well, you had him there. He said just because of little infractions. If we keep on condoning little infractions, would that help our electoral process? I am talking now about Zamfara State. We've moved from Kano, where, of course, the courts is saying the PDP candidate says we have the option of going to the Supreme Court. Elections are going to be conducted. He said the courts didn't say that their principal lost the election or their candidate or the governor, but that some elections are going to be conducted. Now, if there was an error and the courts come out and say it has to be done, will you, because of the people that voted, not do what is right?
Thank you very much. The people have the right to choose their leaders. The people have the right to express their view through the ballot. But that expression and that choice must be done in line with the laid down procedure and the law. If you express your choice and same is not done in line with the law, either as a result of the omission or inaction or action of INEC, or even the voter himself or herself, the law is the law. What is the implication? Such a vote, in the case of overvoting or otherwise, should not stand. And we should not, sacrifice the law on the altar of, sympathy or public outcry. The law is the law, and the law must be complied with. If the law is saying a vote for a ballot paper to be valid, it must be signed, it must be dated, that law must be complied with. Because in the absence of that, it means there is a ballot paper stuffing. It means the ballot papers were stuffed. Because if not, that ballot paper should have passed through the procedure as laid down by the law. If the law says where there is overvoting, the consequence is cancellation, that law must be respected. Because if it is not respected, it will provide opportunity for the politicians to go to the polling units, write the result as the case in Kogi State, write the result as you want, and declare yourself as a good, the other party should go to court. We want to have electoral process